Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana.
Hello once again. It's another Saturday, in fact, the very first Saturday of the month of May 2025. How are you going to challenge deportation from the UK as an overstayer based on human rights? That's the topic for discussion this afternoon on the Community and the Law, brought to you by BWF Solicitors. Let's get into it together. Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with the immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live on Facebook at BWF Solicitors and at BWTV, live on YouTube at BWF Solicitors and at BWTV. My name is Uruku Frimpon, and I want to say thank you very much for joining us this very Saturday afternoon, the first one in May 2025, the 3rd of May 2025. We are here courtesy BWF Solicitors, our trusted partners when it comes to the law. They have been supporting us to bring you this legal education that happens every Saturday between 4 and 6 p.m. UK time. This afternoon is no exception because we're coming up with a discussion on a very interesting and very important topic. We're looking at how to challenge deportation from the UK as an overstayer based on human rights. And our guest and resource person will be Lawyer Charles Asma. He is a lawyer of the courts of the UK, and he will be taking us through how to methodically go through that and get us what basis there is to have to challenge some of these things. Deportation, yes, you've come to live in the UK, you've lived as an overstayer, now they are going to send you away. How you're going to challenge that based on human rights. He is going to guide us through that. But you know what? I always tell you that people have benefited from BWF Solicitor Services and they are grateful. What they do, they go on to Google and give us the reviews and also send them to the BWF Solicitors website and email address. BWF Solicitors will also want to let you know that we appreciate what you have given us. Fifi T has sent in this one. It says, I recently had the pleasure of working with BWF solicitors during my UK ancestry visa application process, and I cannot recommend them highly enough. From the very beginning, the team provided exceptional support and guidance, making what could have been a daunting experience very much easy. And Fifi has gone on Google to give us that review. We advise that you also go there and tell us what you have experienced with BWF solicitors. We'll take feedback very importantly. So definitely, if you send us any feedback, we will work with that and also one, improve our services and get others to enjoy the quality of service we provide as well. BWF Solicitors is on the fourth floor of the Anna House, which is 214 to 218 Tottenham High Road, Seven Sisters, North London. The postcode is N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them on 0208 493 7340. I say the number again, 0208 493 7340. Those of you in Ghana, there is a Ghana office and you can contact them on 055 589 5959. 055 589 5959. In emergency situations, every time of the day, no matter what it is, call the emergency number 0044 77 12 76 1884. 0044 77 12 76 1884. BWF solicitors definitely are trusted partners when it comes to the law, and definitely Fifi T has tasted and seen and experienced what it is. 50, thank you very much. We appreciate that. Those of you who have experiences like that, send them through. It will encourage other people. It will help them also to improve the services they provide. Thank you, Fifi. Well done to you. Nugget, we send out pieces of information at the beginning of the working week, especially Mondays between 10 and midday. And that's for you to, one, empower yourself, uh, use that part as part of your body of knowledge, and also get yourself out of situations when you face them like that. Can you apply for a free waiver outside the UK if you cannot afford it? That's a very big question, and I know people have been asking over the number of days. So let's see what it says. Many families struggle to apply for their loved ones to join them because the applications are quite costly. Applicants will be granted a fee waiver, or the fee will be taken, like you will not be asked to pay the fee, so to speak. They can do that either if they can credibly demonstrate that they cannot afford the fee, or they can show that their income is not sufficient to meet the child's needs. This one has been quoted from the affordability fee waiver. That is a caseworker guidance published on the 16th of June 2022. So the question you are asking, and definitely at the point I'll get Asma to explain that a bit more in a bit more detail for us. Can you apply for a fee waiver outside of the UK if you cannot afford it? The caseworker guidance published in the 16th of June 2022 is saying that applicants will be granted a fee waiver if either they can credibly demonstrate that they cannot afford the fee, or their income is not sufficient to meet their child's needs. So if you find yourself in a situation like that, well, speak to credible lawyers and then they will help you unravel that. So, who would I recommend? BWF Solicitors, 0208 493 7340, or 00233 if you're in Ghana, 55 589 5959, 00233 55 589 5959. BWF Solicitors, we definitely and confidently say they are our trusted partners when it comes to the law. Now, having looked at this, I want to give you a scenario. Just think about it. When we have had the explanation, probably you would be in a very good situation and a position to answer those situations for me. So let me get you the quiz I'll be bringing you later on in the day. Anna Mary is a trader in Ghana and is applying to join her British husband, Kofi John, a cleaner in the UK. Eno has postponed her application for the last 2 years because she cannot afford the $6,500 fee. Oh, that's quite expensive. Which of the following statements is true? Eno can apply for a loan to make her application. As her husband is a cleaner, Eno can ask for a discount. If Eno and Kofi can show that they cannot afford it, the fee will be waived. Which of them is true? Think about it, because at the tail end of the program, I will ask you to give me your answers, and you will be putting that in the comment section down below on Facebook at BWF Solicitors, on YouTube at BWF Solicitors, or you can send it to us via text 07399 208 468. 07399 208 468. So, those of you who have joined us, I've shown you where to go, what to do. And if you have a comment, you have a question, you can put that in the comment section down below and we will pick that one up. But if you come in here, what do? Announce yourself, make the algorithm look good, and we'll also welcome you as well. So those of you who are here, thank you, welcome. Have you shown your name? Have you written down your name? Let me see what I can get here. Yes, Sandra Fraser is here. Good afternoon, Sandy. How are you? Thank you very much. Or please share when you join. That's the thing. So do it when you come in. Hello, lovely family. Tilly Juma. Auntie Tilly, how are you? Long time. Let's get to hear from you. Ade Taribo, good afternoon to everyone. Good afternoon to you. Ade, all the smiley faces. Pastor Augustine Abuaji, oh, good to see you too. PAM TV. Yes, we need to talk. That collaboration should continue. Good to see you, my brother, as well. Pastor Augustine Abuaji, PAM TV, UK. Thank you. Please share when you join. That's Ade also telling us again. Please kindly share, comment, and like. Thank you. Thumbs up to you out there. Um, well, with that, let's take one quick break and say thank you to our benefactors. I'm talking about BWF Solicitors. And when we come back, we'll be looking at a bit of the detail of the nuggets. And then we go into the discussion. What we are discussing this afternoon is how to challenge your deportation from the UK as an overstayer based on human rights. Lawyer Chasasma will be leading that. But before that, let's say thank you to BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yeah. Okay, lovely people. We live on BWTV and at BWF Solicitors, Facebook, YouTube, and all the other social media platforms. This afternoon, as I mentioned, we have Lawyer Charles Asma as our resource person and guest for the discussion. Lawyer Asma, good afternoon.
Good afternoon, Makoku.
How are you?
By God's grace.
Well, if somebody saw us earlier, would have said that we planned going for the same set of colors, aren't we?
Well, they are somewhat, but not same.
Somewhat similar.
All right.
Well, uh, that makes us a good team. Thank you for coming. How are you? How's the family?
Oh, we're doing well. Weather is fine. Sunny, not too sunny like yesterday, but hey, yeah, it's good. It's a
It's
summer
good.
appeal.
Well, thank you very much for coming in. Maybe today I will change the order just a bit. I'll allow you to say your good afternoons and the welcomes and everything. Then I will come your way with the nuggets as I need some further explanation to that and a few questions that may come up. So, ladies and gentlemen, I introduce to you Lawyer Charles Asman.
Hello, viewers and listeners. Once again, thank you for making time. Today's conversation is very, very crucial for an overstayer who is facing deportation. What does the law say will be the remedy for keeping to stay in the UK? But stay put, invite a friend to tell a friend, and we learn together.
Okay. Okay, all right. Thank you very much, Lasma. And those of you who have just joined us, as I said, we will be having that lovely discussion. And if you have your comments, you can put that in the comment section down below. If you have a situation like that, you are going to benefit. But if you also have any contribution to send through, just don't hesitate. You can text that to 07399 Um, there is this piece of information that I want to share. I know many of you have the knack to, because of the program we do here, we have the knack to be able to support people to put in the applications here and there. But remember, you would have to be properly licensed and qualified to be able to give proper immigration advice. There are so many people who claim to be lawyers and are practicing from their car booth. That's dangerous. Look at what I've put on the screen. Border security bill is saying that fake immigration lawyers to face huge fine as ministers prepare new immigration crackdown. The Home Office says that it is cracking down on people who wrongly claim they can give immigration advice to migrants on how to stay in Britain. The Immigration Asylum Act of 1999 already makes it an offense for unregulated and unqualified people to give immigration advice. Some advisors have already been sentenced to prison for this. The law allows the Immigration Advice Authority, that is IAA, to impose fines of up to £15,000 on individuals and firms illegally posing as immigration advisors. BWF solicitors are properly authorized to do that. But this warning is timely, and I believe, Lawyer Charles Asma, you would want to add your voice to this so we can get our people who are doing that to stop so they don't fall foul of the law. Lawyer.
Thank you very much. It is timely, and it's a clarion call for people who are literally presenting themselves as lawyers. And the law is clear, and we have looked at the 1999 Immigration Asylum Act, and it says that to give an immigration advice, you must have the qualification.
Hmm.
Hitherto, government has not been keen on cracking down on those people. But now it's clear, just as employers who flout the law to employ those who do not have the right to work in the UK are able to be charged to pay about 60,000 plus per employee or per person.
Mhm.
Now the law is that if you give immigration advice and you are not authorized, you're going to pay 15,000, and this will deter those who are unscrupulous in their approach to doing these things. And what does it mean? It means that if you don't have the license or qualification, you cannot give immigration advice. So who qualifies? In the UK, England and Wales, we're looking at people who are solicitors, barristers, people who are members of Chartered Institute of Legal Executives, and also people who have license under or from the Office for Immigration Commission to be able to offer immigration advice. So these
Mm.
are four categories of people who can do that. And therefore, if you appear to be a pocket lawyer, quote and unquote, then you cannot give advice. And this is also to those people. When somebody is making an application for you, and the person, instead of putting their details there, they put your detail as if you are doing it yourself. It tells you that they don't qualify to represent you. And that is why when they do that and something happens, there's no evidence to suggest that they did it because everything there is yours. So let's be careful, and this goes to both parties, those who are seeking such advice and those who are giving such advice. If you do it, yes, but you are going to be a victim of such advice. Even though those who give such advice, the law now says that they are going to be punished for a fine of 50,000 per advice they give or per individual that they have put into that difficult situation. Before the law catches up with those people, you would have already found yourself wanting. So, what we are saying now is this: it's already there. Now the government is going to be strict and hard on that. So let's all keep an eye. If you need immigration advice, ask the person, are you qualified to give advice? Or check whether the person is qualified to give such immigration advice. And if you are seeking to do so, please bear in mind that now you have a duty to show that you are qualified. Otherwise, you put yourself at risk.
No, lawyer. So then let me ask this. For instance, I have a brother, I have a sister, I have a friend who is completing an application form and comes to me to say, um, this is the question. Have you ever put in any application or been refused before? Then was I, oh, okay, no. If it is a yes, put in yes. If it's no, or I guide the person through the application and they submitted themselves. In that situation, am I giving advice or am I just assisting the person to complete? What's the difference?
Kindness is not bad within the law, and
Okay,
therefore you are able to show kindness by way of helping. We call them helpers.
okay,
But if you are helping, then you know that you are not going to charge for such help.
okay.
That's one point. The second point is that not only are you helping, you might have already told the person that if we do it this way, it will work without quoting any law. So you are
Okay.
using your experience, feelings, and what you think is appropriate under the circumstance. That is advice. So, what is advice? Advice is telling the person what the options are and what their legal position is. Whether you quote law or not, you have made the person to believe that if they take a particular course of action, this will be the consequence in terms of whether it is workable or not. So the person doesn't have to ask you, do you have qualification to do that? Because for you
Mm.
to be able to tell them that, for example, if you get a COS and you apply for the visa, you will be granted. Is that what the law says? So if the person applies and the person is not granted, you have misled the person. And that is what the law says, that if you give advice that you are not authorized to do so, leading to misleading somebody, then that's an offense. What it means is that those who are qualified to do so will give such advice with discretion, knowing that they are bound to ensure that any reliance on the advice is what they will hold or they will be held accountable for. So if you go to a lawyer and the lawyer tells you X, Y, Z, and you do it, you can always say that the lawyer told me to do that. And the lawyer must have the instruction and advice he gave you before you pursued it. So that is what the law is, or the government is seeking to do to ensure that, immigration is very volatile, where a lot of people are susceptible to vulnerability. And
Mm.
so the government is now trying to make sure, and we know that in recent times, A lot of people have entered the UK and have become victims of circumstance. We have heard that a lot of people presented themselves as legal advisors, got people to enter the UK. There's no job, and those who had jobs, it's not guaranteed. And a lot of people have become stranded, and the government is now picking up the pieces. So, this has informed the need to ensure that this law, which is the Immigration Asylum Act 1999, is properly enforced.
All right. Laura, thank you very much. And I believe that people are taking note of that. If you have any questions about this, you have any doubts, you can call BWF Solicitors on 0208 493 7340, and they will give you further explanation and also advice you. But I would advise that, as I keep saying most of the time, it's always best for a layman to give his work for an artisan to do for him or her. Well, with Laura here, let's quickly look at our nuggets and get some more uh, uh, detailed explanation of that. The question is, can you apply for a fee waiver outside of the UK if you cannot afford it? Laura, can I put this question to you, please? Please, you're
It's
mute.
clear. So we're looking at fee waiver, what fee waiver is,
Mhm,
and we'll tell you why the silence in the law means that it's open to any jurisdiction where the applicant is. So a lot of people thought that you can only do it when you are in the UK. And so the question now is, can somebody outside the UK still apply for fee waiver? Now let's look at the legal context. One, fee waiver is for those who cannot afford immigration application fees.
mhm,
And two, even if they were able to afford, it means that they will find themselves not able to meet essential living needs. And three, if they were able to meet essential living needs for themselves, it means that they cannot meet the essential living needs of a child involved. So, well, if you have a child, it's even serious. If you don't have a child yourself, if after affording it, you cannot meet your essential living needs, then you'll be out of pocket. Then that will lead to destitution. So destitute situation, imminent destitution, or child issue vulnerability as a result of you having to pay. Question: is it compulsory that if you don't pay, government should help you? Hence, fee waiver. We take you to Section 6 of the Human Rights Act 1998. The law is clear. It says that any act, any decision, or anything the government does that affects other people's ability to exercise their human rights, that act, that conduct, or that decision is incompatible with human rights. That's point one. So if
mhm,
the government says that you have to pay a fee, and that fee has become a condition, and that condition means that you cannot, without meeting the condition, exercise your right and Article 8 of human right to apply with a family or under your own self private life, then
mhm,
that condition restricts you. And so that act by the government will be incompatible. So, which is first? Human right is an enshrined right and therefore unfettered. And so anything that tend to interfere or get in the way of that right cannot stand. The government say pay a fee before you join your family. That decision to pay a fee cannot stand because if it stands, you cannot exercise your Article 8 right. Question: is it only for those who are in the UK or anywhere? We are talking about human rights. Human right is no respecter of jurisdiction. And so whether you are in the UK or abroad, insofar as it's a human right, then Section 6 can be engaged if your inability to pay because you are applying from abroad and the government is forcing you, for example, to pay before you can make that application will be in contravention of that law, and hence your inability to exercise Article 8 rights. So, can you apply from outside the UK for a
mhm,
fee waiver if you cannot afford the fee? what you have to show is one, the application you are seeking to make is a human right application. One, that you are joining your family in the UK, be it your child, your parent, your spouse, or grandparent. Of
Okay.
course, if it's under immigration rules, you cannot join your grandparent unless, of course, it's under adult dependent relative application. So any application that is for family or joining a family is a human right application. If you can't afford, then the government should allow you to exercise the opportunity under fee waiver rules. But it's your duty to ensure that you meet the fee waiver or rules. Why is it that the government introduced rules or conditions for fee waiver? So when the government was challenged why there is a fee condition for human rights application, the government accepted that no, that is in contravention of Section 6 of Human Rights Act 1998. However,
Okay.
it will not be a blanket opportunity. Those who cannot afford must prove that they cannot afford, and that even if they are able to afford, that will lead to their inability to meet their essential needs for themselves and their children. So if you are seeking to get a fee waiver, you just have to show that the factors are present or the criteria are met. And it doesn't really matter where you are applying from. Insofar as you meet the requirement, you should be able to be heard and your request for fee waiver considered.
Well, so the conditions are there. If you can credibly demonstrate that you cannot afford the fee or your income is not sufficient to meet the child's needs, you could be granted a waiver. Yeah, there's an operative word here. Applicants will be granted. So does it mean that if you satisfy these two conditions, it's automatic?
So I mean it's a merit based. If you deserve it, you must be given. How do you show that you deserve it if you cannot afford? How do you
Okay.
show that you cannot afford? You just have to show your bank statement and your earnings. Insofar as it proves, then you must. So the operative word is a mandatory word.
Okay. Well, ladies and gentlemen, if you need any further explanation, I believe you can call BWF Solicitors on 0208 493 7340. Or you can call Lawyer Charles Asma himself on 07947. Um, I always have to make sure that I get it right before I give you a wrong number. Can we can we, can we put it on the screen for my viewers? 07947 636 Forgive me. I just don't want to quote it from my head so verbatim and I get it wrong. 07947 636037. 07947 and he will help you. He calls this one the line of hope. So definitely you will have something to go away with when you call him. Do call him and he will help you. This afternoon, he's here to help us look at our discussion. So, having had that explanation, I'm going to ask you my question. There are three statements I'm going to give you and ask you if those statements, which of the statements will be correct. Eno Mary is a trader in Ghana and she's applying to join her British husband, Kofi John, who's a cleaner here in the UK. Eno has postponed her application for the last 2 years because she cannot afford the 6,500 um, dollar fee. I kept thinking in my head, do we pay dollars in Ghana? Well, that's a scenario, so I've given you. But then I'm asking you this question: which of
Yes,
these
we
three
do. We
statements
do. Ragogo,
is?
Ragogo,
Yes, sir.
just to say that yes, that is the position. Because the person is applying from abroad
Mhm.
to enter the UK, so they will not pay
Okay,
pounds, and therefore it is quoted in dollars. Immigration fees abroad are quoted in
quoted it
dollars.
in dollars. Okay, well, thanks for the clarification. So then let me push my statements and I'll ask you, my dear viewer, listener, and friend out there, which of these three statements is true? Eno can apply for a loan to make her application. Is it true? As a husband is a cleaner, Eno can ask for a discount. Is that true as well? If Eno and Kofi can show with evidence that they cannot afford it, it would be waived. Is that true? Think about it. We'll come back to it at the tail end of the program. But in the meantime, let's once again say thank you to BWF Solicitors. And when we come back, we will be going straight into the discussion. We're going to put up a challenge. How are we going to do that, and what kind of challenge is that? Don't go away.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, BWF Solicitors, thank you very much. I believe that people are taking note of that. Now, if you're going by public transport, let me advise that if you go on the train, take the Victoria line to Seven Sisters. And when you get out of the train, use exit number 2, and that will take you to the front of the Anna House. Climb up to the 4th floor. BWF Solicitors are there. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. What are we discussing this afternoon? If you just joined us, we're live on Facebook, live on YouTube at BWF Solicitors and at BWTV. How to challenge a deportation situation from the UK under the um Human Rights Act, and also we are saying, or you are being accused of overstaying. What is happening? How do you do that? Leah Charles Asma, how do we do this? Please take us through it. And I know definitely you've got loads of things, steps, very calculated steps. The law, you base that one on, and all the rest of it. We are ready for you.
Sure, sure. Hello, viewers and listeners, once again. Welcome to the conversation: how to challenge deportation from the UK as an overstayer. So, there are three dimensions to this conversation. We're looking at deportation, which is an act by the government, which is a duty to ensure that there is immigration control in the UK. We're also looking at overstayer, which is for people who have run out of their leave or visas in the UK. We're looking at human rights on the basis that there is protected right of the individual despite being an overstayer, to enjoy family life or private life, or to ensure that they are protected from act of persecution or inhumane and degrading treatment if they are sent away from the UK.
Mm.
So these are the three dimensions.
Okay.
We are going to rely on immigration rule under Appendix FM. Appendix FM, paragraph 6.2, to do with paragraph 6.2 to do with partners. We also will be relying on Appendix relationship with a partner, paragraph 5.1, 5.2, to show there is subsisting relationship with a partner. We also will be looking at the policy on deportation and what the person can do in terms of challenging such act by the government to be removed from the UK. So we know that when you enter the UK, you are restricted in that if you come as a visitor, you have to leave within a certain time. If you are given 6 months visa, even within the 6 months, you told the government that you stay in the UK for a particular time. And so when the time is up, you have to leave and possibly come back. If you are granted 10 years, 2 years visa, it doesn't mean you have to stay in the UK for all that. And now let me take you to part 9 of the immigration rules, paragraph 9.23.1, which says that when your condition of entry has changed, in other words, if you have changed your mind in terms of what you came to the UK for, then your visa can be taken away from you. And once that happens, you become an overstayer. So if you now look at different ways that somebody can become an overstayer. Overstayer simply means that you have become an illegal resident in the UK.
Mm.
Now, the government is required to ensure that immigration is controlled insofar as is possible. And so only those who are required to be in the UK are allowed to stay. We also are aware that not all those who are living in the UK are required to live in the UK. And therefore, anytime somebody is stopped or found to be without legitimate leave to remain in the UK, the person, if they are subject, of course, if you don't have legitimate leave to remain in the UK, then you are subject to immigration control. If you are subject to immigration control and you cannot prove that you have basis for being in the UK at the time, you become a subject for removal. Removal means that they have to prepare you to send you away from the UK. In the meantime, you'll be questioned, you'll be interviewed, and depending on the circumstance, you may be granted immigration bail, or where you are not granted immigration bail, you have to be sent for preparation to be deported. That's you are sent to an immigration detention center for the paperwork to be done. Question: whilst I have been asked to leave the UK because I don't have a leave to remain in the UK, can I challenge that decision to be removed from the UK? And that is the basis of this conversation. So we are looking at human rights. What it means is that if you have human right to be in the UK, then your the basis for deportation from the UK may create some other issues for other people. And when other people's rights or your right under Human Right Article 8 of the European Convention on Human Rights is affected or brought into question or endangered, then the act of the government again will be incompatible with Section 6 of the Human Rights Act 1998. So the government wants to deport you. You have human rights with your family to remain in the UK. Can the deportation affect your right? And if it does, will the act of deportation or removal from the UK be in breach of Section 6 on the part of the government? I say yes to a very um, high or great extent. And you see that I say to a great extent because much as is yes, if the caseworker or the Secretary of State is able to argue that the act will not be in contravention of your right under Article 8, then the extension will not be at play. That means it can be sent away. So how do you show that yes, you are an overstayer, but you have human rights and therefore your removal from the UK cannot be acceptable?
Hmm.
How do you prove it? So first, you've been in
Uh,
the UK to visit, for example, your husband or your wife or your family member, so to speak. And whilst in the UK, your family member becomes seriously unwell, and you are looking after that family member.
okay.
Mind you, if you go away from the UK, even with the best of intention to follow the rules, to meet the conditions of your leave, to leave on time, your departure will affect the well-being and welfare of that particular family member.
Mhm.
Yes. If it is so, then it becomes a dilemma for you to leave or to
Or
remain.
to green.
Remaining means you are breaching your condition of stay. Going means you are going to put your family member in jeopardy. So it's a matter of law and morality. And when the law clashes with morality, it appears that equity will prevail, what is fair at the time. And what is fair at the time will be to stay on to ensure that your family member is able to survive. Because
Mhm.
mind you, if you go and they call you that your family member has died because you couldn't bother to stay on to
To
look
stay
after
and
them,
take care of the person, yeah.
but you say that, come on, I had a duty to comply with my immigration rules. And so it was the right thing to do. By doing that, life has been affected. So what do you
Mm.
do?
What do
So
you
let's
do? Yeah.
assume that this individual has taken to ensure that their family member's life or well-being or welfare at the time is protected or ensured.
Mm.
And
Mhm.
so they have become an overstayer. The question is, having become an overstayer, we want to send you away. Do you have any family life right to rely on to be able to stay on? If you are a husband or wife or an unmarried partner, you have to show that you have familiar relationship. In other words, this person is your spouse. So again, that's why I made reference to paragraph 6.2 of the immigration rules, which says that if you are a partner or unmarried partner, you have to show that one, you are married if the person is your partner, or you've been in a relationship for 2 years with that person,
Mhm.
even if you are not living together.
Okay.
And if you have been in a relationship with a person for 2 years without living together, the person is your partner under paragraph 6.2. Again, the caseworker will refer to paragraph 5.2, 5.1 of Appendix Relationship with Partner, which says that RWP 5.1, 5.2 says that to show that you have a relationship with a partner, you have to show that one, the person is your spouse, which is your wife or husband,
Husband,
or
yeah.
two, you've been in a relationship with a person for 2 years. It used to be relationship for 2 years plus living together. And living together has been taken away. And it's been taken away for it's been taken away for good reason. And the reason is that if you are telling me that I have to show that I'm living with my partner, even though we are not married, before we can show relationship. Meanwhile, relationship is never existent on geographical location. Relationship exists in the heart and the mind. And therefore, it doesn't really matter where I am in the world. Insofar as I can prove that the person's soul and being rest within my heart and my mind, then I'm in a relationship. And that is why cohabitation was removed from the law. And it has a reason, sociological reason. Now, I'm able to show that this person is my partner, but we are not married, but we've been together for 2 years. This person has a condition. If I stay on, or I don't want to stay on, but if not even because they have a condition, I just want to stay on to have family life with my partner. Then we take you to the aspect of the law, which says that if you want to stay on with your partner and your partner has a child and you are a step parent to that child, then if the child is a qualifying child, i.e., the child is British, the child is an EU national with pre settled or settled, or the child has lived in the UK for 7 years or was born in the UK and has lived for 7 years, the person is a qualifying child. And on that basis, you can remain with that stepchild. So you see, there is a factor introduced. And the factor introduced into this conversation is that there is a child involved. And so, under Section 55 of the Borders Act, if there's a child involved, then the caseworker cannot make a decision to deport this individual without considering the paramount interest of this child involved. And
Okay.
if by deporting the person is going to affect the well-being, the welfare of the child, then the decision will be incompatible with Section 55. So, where there is no child, then you have to prove that your spouse or your unmarried partner has some situation that will mean that if you leave the UK, if you leave them behind, your absence will create hardship for them. And that is where we started the conversation by talking about if you are caring for them, you are looking after them, and they depend on you for their well being, welfare, and survival, then that is going to be an insurmountable obstacle for them. Not insurmountable obstacle to survive in your country, but insurmountable obstacle for them to remain without you. In that, when they are here without you and you are doing everything for them in terms of supporting mobility, supporting eating and drinking, and all that, then your absence will create hardship for that partner. So, if
So,
you're able to
so
establish,
yeah, just before you go on, let me get this little clarification. Now, the human rights we're looking at here is the human rights of the person who would be affected if this person we are talking about is deported. For instance, if I am the carer of or the main carer of my spouse, my child, my parents, or somebody who would one way or the other depend on me, if I am deported, that person may not be able to survive. So we're looking at the human rights of that person, not me.
I agree. That would be a third party right of that person
Okay,
because that person becomes a third party. So the
okay,
first party is yourself, second party is Secretary of State, and the third party is any person with beneficial interest in this conversation.
okay,
Yes, it is the person who is subject to deportation's right. The
okay,
person has family life with this family member who is needing support from this individual, the subject matter.
okay.
So much as we are saying that the person needs you, we are not saying that the person family life is to need your help, but your family life to be with the person. And the person being your family member, we are now saying that you have established the first factor, which is familiar relationship,
Relationship.
Article 8
Okay,
right. But Article 8 right is again um, sort of put into some conditional situation where if there's no child involved, so there are two parts to it then. The first is to be able to ensure that you can rely on your Article 8 right as a family member. You have to show that that decision to prevent you from exercising your right will affect a child involved. So the child factor. Or you have to show that by preventing you from exercising your human right is going to affect that family member's other needs. That is the hardship factor. So the hardship of the third party and also the hardship of yourself if you are to be sent abroad. So the third factor to be considered will be insurmountable obstacle for yourself. For example, you go back to your country and there are other issues that will make your ability to survive in your country difficult, then we're saying there are insurmountable factors. But
factors.
those insurmountable factors may not be that obvious. For example, is there a political reason that you can't survive in your country? Is it a cultural reason that you can't survive in your country?
Okay,
Is it socio-cultural reason or economic reason? If it's economic reason, what you are going to say is that I cannot reintegrate and have a living. But that is nobody's business because you can still start afresh because you were born in that country, especially if you haven't been away for that long, then you can easily reintegrate. So they will pick up that rebuttal with you. If I say they, the Secretary of State. If it's cultural, what sort of cultural issue are you going to pick up? Is it that you are now in a relationship with somebody who is the same sex with you? So you are now a gay or lesbian, and you are in a relationship with your gay or lesbian partner. Then there's going to be insurmountable obstacle depending on the country of origin. If the country of origin frowns on such practice, such as same-sex relationship, then you are exposing yourself because the moment you go, you are going to be subject to the law or subject to cultural punishment. And so there is insurmountable obstacle to be able to survive. So much as you have a relationship with this gay or lesbian partner, if they prevent you from surviving from staying on because there's no child here, then you going away, you can argue that my Article 3, 4, or 5 right to be affected because I'm going to be subject to some persecution because of the new lifestyle I have adopted.
Okay. Right. Um, we have had the premise of the whole situation. The next and obvious question is, how do we approach it? If the lawyer who is helping you put in this application sits down with you, what questions are you supposed to help them answer? What do you need to put together to face the situation and get over it? We're taking one quick break, and when we come back, lawyer will take us to the next phase of the discussion. But keep your comments coming through 0739920848, or you can put them in the comment section down below, either on Facebook at BWF Solicitors and on YouTube at BWF Solicitors. You are with us live, and it's the Community and the Law brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. We're still live on BWTV, bringing you the community and the law discussion, how to challenge deportation from the UK as an overstayer based on human rights. I would want to uh, appeal to you, ladies and gentlemen, my brothers and sisters. Every year, the Alexa Champon Foundation does a concert to raise funds to buy incubators for needy hospitals back in Ghana. Now, this Emmanuel Praise program came about because the founder of the ministry had a situation where if he had not had the um, opportunity of getting an incubator to put his child in, the child would have died. And we have taken upon ourselves to make sure that children who would need incubation, preterm babies, so to speak, we will support them. And it happens on the last bank holiday in May every year. And this year is the 25th of May, 2025. Emmanuel Praise. And I'm asking you to help and support so we can help the needy, um, starting from back in Ghana and other places as well. Watch this.
Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Doors open at 5, with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP, includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexichampon.com or call 0744 741 7321. Emmanuel Praise with Irabna and Joyce Blessing and hosted by Alex Champon. It's guaranteed to be awesome.
Thank you very much for sticking around. And I believe that on 25th of May, you come support. If not for anybody, come support me. Yours truly will be hosting the event, and I believe that it's going to be an awesome experience. And we'll have the opportunity of supporting children, preterm babies, to survive and become somebody in the future. Thank you, and thank you, BWF Solicitors, BWTV, for supporting this one. We're having a discussion, as I mentioned earlier before we went on the break, how to challenge your deportation from the UK as an overstayer based on human rights. Lawyer Charles Asma from BWF Solicitors is here taking us through that. We're going back to his desk, and we're going to look at how to do that. Lawyer, we're back with you.
Thank you very much. So I'm going to rely on a practical or a test case, so to speak, because you see, it makes it interesting and relevant when you are relying on a practice or experience of how this works. So it's not just about theory, but it's about what has worked before. Now, so there's a case where the person visited the UK 6 month visa. When the visa was, or when the person was due to leave, the person did not. So I will put this person as person B. So B stayed on, and eventually B was apprehended by the border force. B became a subject of removal from the UK. So B had to go or stay on. So B engaged our service. And B's instruction was that I came in, but I've run out of leave. And I was caught working at a salon. I wasn't actually working, I was only volunteering. And the people said, one, I'm working without leave, and two, I have overstayed, so I have to leave. The person, by the time we took the matter up, the person had about 21 days. Person had been in detention as well. So taking the person's instruction, we understood that the person has a boyfriend in the UK.
Mm-hmm.
They've been together for 2 years, according to the they've been together for 2 years, according to the person's instruction.
Yeah.
So, what it means is that within the rules, the person has a relationship with this boyfriend for 2 years. They are not married. They are not married. So, this person is not a spouse. The person is an unmarried partner. The law says that under paragraph 6.2, an unmarried partner is somebody that you have been in a relationship with for 2 years. But then you have to show that the relationship is subsisting. So this person had to show when they started the relationship and up to date evidence. The third thing the person added is that my boyfriend has been unwell, he's been in and out of hospital. And that is why at the time I was due to leave, he had had an operation and recovering, so I had to stay on. At the same time, he has a child in another from another relationship, and he has direct access to the child. That means the child visits him, and the child lives with the biological mother. So whenever the child visits him, she supports the well-being of this child. So there's something then created in terms of the person's Article 8 and also those other factors that we discussed. One, the person has family life with this individual or the partner. Number two, if the person were to be removed from the UK, it will bring hardship to this individual because she is there to assist this person in terms of post treatment support. At the same time, there is a child, and she being stepmother to the child or parent to the child, she's supporting the child's welfare and well being needs. So, what you do is because the matter is already with the borders, you put in application for human right claim because what you are claiming is that you have human right to this person or you have human right to be in the UK.
Yeah.
So you put in a human right claim, and because this human right claim is based on a parent and a stepchild, you have to look at the law and look at the requirements. Look at no, so not a parent, a partner. So you have to look at the law and the partner, and again the law for child. And the law for partner is Appendix FM, spouse, leave to remain. So you have to show all the criteria in terms of the relationship, in terms of the finance, in terms of accommodation. So even though you are making a human right claim, you still have to meet the requirement for that particular application supported by your human right.
Yeah.
So the human right for this person was as a spouse of a British citizen and also as a step parent of a British child,
Okay.
qualifying child. So two aspects of the immigration rules are tested here. One, on the basis of your partner, which is partner root, and also on the basis of your child, parent root. Both put together, and we set out our case for human right claim. Immediately, the matter went to them or the request went to them, and this one is it's not online. You draft it or write it and send it to them by email, so it is not online. Let's distinguish between the two. So human right claims, for this under this circumstance, you send the application to them and you don't have to pay any money. There's no application fee for such claims. Once the claim went, within a week, they came to say that they have rejected the claim and they have certified the claim. Certification of claim is where the person's argument or reasons are not accepted. And so there's no way the person can progress to appeal or otherwise. That means the deportation will stand, the removal will stand.
Okay.
So then we had to go to court for judicial review because a decision to certify a claim by a public body is a decision. If the decision is not rational, if the decision is not lawful, and if the decision is perverse, then it's subject to judicial review. Remember, we said that judicial review is always possible where the decision of the Secretary of State or public officer is incompatible with the rules. So we relied on that part of the law to say that you have decided not to give the person an ear or listen to them to have that claim to remain with their partner or child. You have certified what it means is that a person cannot even appeal against your decision. So we want the court to review it.
Hmm.
So it went for judicial review. In the meantime, we had to apply for bail for this individual because the person was in detention. We are not discussing detention matters. We are discussing the fact that when you are subject to deportation as an overstayer, you can rely on your human right to fight the deportation or the
Okay.
removal. But if you're already in detention, then you have to be granted bail. That's tribunal court bail because you cannot be in detention and fight your case in court because
Okay.
the removal is no longer necessary. That is the law. If the removal is not necessary or imminent, you cannot be kept in detention.
In detention. Okay.
And you know why they certified the claim? Because if they had not certified the claim, then they had to ask the person to leave detention immediately. But to certify the claim, it means we don't accept your argument or your reason to remain, and you don't have right of appeal, so we are taking you away still.
Away.
And if we are taking you away, then removal is still necessary.
Okay.
And if removal is necessary, you cannot be granted bail. So that was their reason for doing that. And our reason for doing this is to say that we are going for judicial review to challenge your decision, not to give this person opportunity to fight their human right claim. And that decision is incompatible with the law, Section 6 of Human Rights Act. And
So,
so,
so lawyer, sorry to cut you, but let me ask this one. If you put in an application to say that this person's human right is under threat here, so we're putting in an application to stop it, so we can fight the situation. The person can prove that there are circumstances in their life, so they have to stay, or they have overstayed because of these circumstances. Does it stop the clock in any way? The clock of getting them to deport you, the clock of any other thing that would happen, so the person would come out of detention and live his life until a decision is made. Does it stop the clock in any way?
well, it's not a matter. There are some instances where the clock matters, but there are also instances where equity matters, and therefore delay would defeat equity. Because if you have a case to fight, then you have to fight it immediately. You
Okay.
don't wait later, and come and tell a story to assert your claim. And so the moment it became obvious that you need to rely on your human right is when it became obvious. And in this instance, when the person was being removed from the UK.
Okay. All right.
And
I asked about the clock because I think the example in this situation, as you gave, when the case came to you, the person had a few number of days to be taken away. That's why I asked whether I stopped the clock in any way, your action.
oh, right, okay, I get a question now. What you are asking is by putting in the human or by relying on your human right to make a claim
Mhm.
to stay on, does it prevent or stops your removal?
Yeah.
All right. So it is not the clock per se, then it is the action.
Okay.
So the action to remove you will be stopped because then the action is no longer necessary.
Right.
Because the person has, so the rule is that if I have an application pending, you cannot send me away.
Okay.
And that is why they said that the person didn't have a case and that the person cannot appeal. And the only way to move on is to go to upper
To the court.
tribunal for judicial review. And for going for judicial review, it's an immediate thing. So the moment the decision came and the person was denied the opportunity, we had to put in the judicial review request. Court will ask you, do you have a deportation pending? We say yes, because there's removal action. And then you have to do another application to show that decision is necessary and immediately required from the court. So court picks the matter, and in this case, within 48 hours, court came with a decision to grant permission for judicial review.
Okay.
And once court granted permission for judicial review, what it means is that the Secretary of State then cannot pursue the removal because there is a matter before court and they can't say go and fight from abroad. So you have to stay on. And if I'm going to stay on, why should I be in detention to fight the case? And it became necessary for the person to be removed. And for this particular case, the removal direction was set 3 times. And in all 3 times, we were able to get them to change it. And eventually the person was granted bail. And decision came. And they then give the person the opportunity to fight on in terms of the judicial review, which is the court. So then caseworker or the Secretary of State came back to say that, right, we have checked your argument, we have followed your everything you have put together, and we believe that judicial review is likely to succeed. So we are going to reconsider the decision not to give you opportunity to make a human right claim. And so the matter had to be taken from court. So the Secretary of State or the caseworker accepted for the matter to come out of court. But the key thing is they then made a decision. And the decision this time came with right of appeal.
Okay.
And now, once the person was given right of appeal, the person can then appeal to court. And in appealing, it's just like any other refusal. So you are appealing to fight your human right claim or case.
Mhm.
So first thing, you were not given opportunity, and now you have been given opportunity. The point here is this: that where you have human right claim and the claim is not successful, you go for judicial review. And where you are successful at judicial review, the Secretary of State or the decision has to be reconsidered. In reconsidering, they will grant it by approving the visa or they will refuse it. But they have to refuse it within the rules. So in this case, they refused it and gave the person appeal right. And they said that even though we don't have evidence, because first they said they don't have evidence of 2 years relationship, and we're able to go back with our evidence. Then they came back to say that what shows that if she leaves, the boyfriend will be in hardship. We're able to rebut that. And they came back to say that your child has a mother and the mother can look after the child. And so it doesn't really matter whether you are around or not. The child then the boyfriend has direct access. And anytime the child is with a boyfriend, this stepmother is there to support. And so it is important. Again, we made that argument. And that got them thinking. And because they still insisted not to appear to have abandoned their case or the fight, they reconsidered and refused it and gave the person appeal. Once you have appeal, it means you can now go to court and fight as if it's a normal refusal.
Okay.
And
Well,
as I speak to you, this individual is still in the UK and the case is now in court for appeal.
so then I would want you to at least decipher from this that if you can do it, you can do it with the right organization. BWF Solicitors is one of the best that you can speak to when you are faced with situations like this. If you are to be deported because you have overstayed, don't just say, okay, I've packed my bag, I'm going. Because there may be some circumstance that you're leaving behind that will affect your human right, your relationship, your familiar relationship with one person that will be left in the UK, either your child, your spouse, or somebody that depends on you. Don't say that it is a desperate situation. seek for help and talk to BWF solicitors. They will help you challenge the deportation. And as lawyer Charles Asma has said, there's one day handling and it's going quite right for this client and this individual. Lawyer Asma is still here. I know you may have your questions. You would want to call us on the phone. The text number is available 0739920848, or you can call us on 0208 493 7345. 0208 493 7345. Or you put them in the comment section down below, either on Facebook or on YouTube. We're live, and it's the community and the law. We'll be right back after this. Welcome back, and thank you for joining us and sticking around. As I said, your questions and your comments are welcome. Lawyer Charles Asma is here, is ready to pick them up. And it could be about the topic we have discussed this afternoon, or any other legal and immigration question. Remember, the text line is 0739920848. The number to call is 0208 493 7345, and we will get you to speak to Lea Asma. Hello.
Hello.
Yes, good afternoon, my dear. How are you?
Good afternoon. Thank you. I'm fine, thank you.
Good. Yes, please go ahead.
Okay, Mr. Chow, Mr. Chow, my application, I call in my almost sending me a wrong form, it's a wrong form, which is a parent root, indefinite on parent root.
Okay.
Okay, almost private life instead of, I think, family life.
Okay.
Intimate and Mr. Chow, me feel it for now, which is family life forms now. But I need to message me document no account be na biometric no, and now say it's just me fill it form no kwa one. Because almost send me letter say me to me the new form aba.
Okay, so they didn't refuse it, but Omo can also meet me the new form aba.
In fact, I don't kind of meet me the new form. When refuse, you almost said me 14 days to change the form.
Okay, so last one, she's trying to find out if she's completing a new form, does she have to attach the same set of documents, or once they have it, that's it? And go and do another biometric maybe.
Okay, let me try to say.
Maybe the answer.
Hold on.
How are you?
What's the last one?
How are you?
Thank you.
Okay. You know what you can do for us? Just go down on the volume of your computer, TV, and speak to us through the phone.
Okay.
Thank you.
Okay. I'm fine, thank you, lawyer.
Good. I'm glad that you are in sync with the language. So then let's go by this language so that others can follow your story. So I'm gonna express myself in English. All right. So the reason why they gave you 14 days is that you can apply correctly. And applying correctly, of course, you're going to do it online. So you do the online application and you go through the process. Even though you've done the biometric and all that, the biometric enrollment is linked to the original application reference number. And because you are going to put in a new application, the reference number will change. So it will be important that once you have finished, you book an appointment to go for your fingerprint. But in terms of the document, evidence that you have provided will be the same evidence because that is what you thought you were doing. So what is changing is the application form. But in terms of the biometric, you can argue that I've already done my biometric enrollment. Why do I have to do it again? But they will also argue back to say that you did it under the wrong heading. So go and do it again under the right heading, which is the correct form with the correct reference number. Okay?
Okay.
Okay.
Okay. Me pacho, another quick one. See, me pacho, in this case, we can almost new application. I have to pay again and sign on my refund. Yeah, man. Is that how it's supposed to be? And I can listen to some application, no? Because I'm more than I'm confused.
I understand. How much did you pay?
That time was 2,800 and you know.
To 885.
December, yeah. So now they added more.
No, take your time. So you paid 2,885. Then was that
Me pacho,
for indefinite leave to remain, right?
me pacho,
And are they asking you to do correct application for indefinite or do correct application for 2.5?
No, for indefinite.
Correct application for indefinite.
Yes, that's right.
Okay, I get it. Okay, so okay, I understand. I understand. Because we are going to put in a new application, what it is that you have to apply to pay. Because the application system will not know that you have paid money already. So what you do is that once you pay, then the one you have already paid will be credited to you later.
Okay.
Unfortunately, you have to find a loan to pay for now and use that as savings, which will come later to you. Okay?
Okay. Okay, lawyer. Thank you very much. Thank you.
Well, thank you, my sister, as well.
Yeah.
And you came to the right place because you have gotten the right answer. 0208-493-7345. Send a text to 0739920848, or you can leave it in the comment section down below. The lines are active, but in the meantime, let's see what we have on the platform if there's any. Let's pick up your comments on Facebook, on YouTube. Emmanuel Ado is asking, Laura, good afternoon. I would like to know what type of application form to use for indefinite leave to remain if I have a British child.
Right. So indefinite leave to remain for yourself or for that British child?
Um,
Oh, anyway, sorry. If you have a British child, of course, then you wouldn't apply
then
for it
it's
now.
a person.
Yes.
Okay.
Yeah. Okay. Yeah, we get it from the story.
Mhm.
So there's a Latin phrase in law which says that res ipsa loquitur, which means the fact speaks for itself. And the fact is clear. I don't have to come back to ask for the same clarification. So you are right, Emmanuel Adu. Now, you are applying on the basis of your child. I'm sure you were there under direct access or any other provision. So on that basis, you go for set LR to be able to. So depend. So when it comes, there are so many forms for indefinite. And again, when people come, the story pattern will determine which one to go for. There are some people who stayed on the child application 2.5 for 10 years. Yeah, 2.5, 4 times, making 10 years. Or some people were students, they switched to parent, they went to some other category, and now they have done 10 years. So if yours is like that, where you have stayed for 10 years in the UK legally, and you are now applying to remain in the UK, then you can apply using form set LR. But if not, if yours is on the basis of parent living with your spouse and also the child or direct access provision, then you are going to use set dependent adult. So set dependent adult. Dependent adult is where you dependent on the child to be for your immigration status, and you've gotten to a point where you are applying to remain indefinitely or settle in the UK. So either it's going to be set LR or set dependent adult. So these are the two. But if you want to call later so that we get the bit about yours, then we'll be able to say A or B. But if you're able to relate your story to what I have said, then these are the two that you are looking for and match it to suit your situation.
Okay. So yeah, lawyer saying that if you want to call later, you can call lawyer Charles Asma himself on 07947636037. We're going to the phone lines now because we have one of our very own on the line. Hello.
Hello.
Yes, good afternoon.
Good afternoon. Good afternoon.
Oh, Antubam.
Yes,
This time I have recognized the voice.
yes, I know you. I have a question about this fee waiver, and I know Asma is going to help me out. Asma, with this fee waiver from outside, also human rights, I know when you want to go and bring your spouse, it's also a human right,
Mm-hmm.
and then have to meet the financial, whatever, which is 29,000.
Yeah.
And you have to beat that 29,000. And at the same time, after meeting the 29,000, you are saying you cannot meet your finances back for your partner to join you. So your partner is going to apply for free waiver. If that is the case, why don't they allow us also to apply for free waiver to the 29,000? That might be a bit of naive question. But what is it? You said you can bring your spouse, so you have to meet that amount. And now they are allowing us to apply for free waiver. So my question: why is it
So,
that?
so if why is it that if you can meet 29,000 that threshold, why is it that they're allowing you to apply for fee waiver? Yes, Laura.
Yeah, Antubam, how are you?
Welcome back.
Okay.
Yeah,
I think he will listen from where I think he's driving. So it's a bit,
good.
yeah. So
So,
obviously his question is why is it that you meet the 29,000 threshold,
okay.
then
Yeah,
you don't need to
Antubam,
have the fee waived?
yeah, Antubam is asking if fee waiver is possible from abroad, why should they charge at all? Or why should they
Yeah.
ask people to meet the financial requirements so that they can
Requirement.
pay
Yeah.
a fee?
If they would grant that, yes.
Exactly. All right. Now, Antubam, this is the analogy to your question. And once I give the analogy, the understanding of the analogy will answer the question for you. So, this is where we say that everybody who wants to have food for free should come and collect food. But when you come, we'll scan your belly to show whether you have eaten or not. Because we have to give you the food and you have to eat it now. But if you have food already in your belly, then you don't qualify. We won't give you again because that would be greed. So your ability to get food is subject to the emptiness of your belly. So when you come and we scan your belly and we see that there's food already there, we won't give you the food. But we say that you have already eaten. So you don't deserve this. All those who have already eaten, knowing that they will scan to see whether there's food in the belly or not, they won't come because they will know that they will be found out. So even though it is open to everybody, not everybody will go for it because you have to show that you deserve it. Now, to answer your question, fee waiver is open. And the reason is that if the person is making a human right application and they cannot afford, and you prevent them from applying, then that would be breach of law on the side of Secretary of State. So they have made it open. What they are saying is that if you can prove that you or your sponsor doesn't have money, then we are happy to waive it for you. So you bring all your bank statements, all your pay slips for us to see. And if you know that you are working and money is coming into your account, you won't even bring it because they will scan your belly and they won't give you the food. Does that make sense?
Yes, it does make sense. So obviously you have to weigh yourself and let us know whether you are qualified because obviously, as lawyer said, there's food. Come, but when you come, we'll find out from your belly if there's food in there. If there's no food, we'll give you. If there's food, we'll ask you to go away because it's for those who do not have food in their bellies. I think that analogy is quite simple and straightforward. Well, let's say we are still within the time that you can call in 0208 493 7345. Honey Boateng, please, what's the right form to use when you have a British child and you are applying for indefinite leave to remain in the UK? Since there are a lot of forms and it's very confusing. I think the previous one uh, is virtually the same question, and lawyer has kind of advised on that. So you need to tell your story, and you will be directed to the
Yeah,
right
yeah.
form.
But I'm a clear
Anything
defense
you want to
counsel.
add, lawyer?
Yeah, yeah. I will say that I was actually going to come back. What I said before was so if it's based on that a child family member throughout, then you go for you. I think earlier I mentioned set dependent adult, but it's called set dependent relative. Set dependent relative, set DR. So it's a dependent relative for those who are parent and they have dependent on the child throughout. But for those people who have been to different categories throughout and they are now deemed for indefinite, they use set LR. So all that I'm adding to this is that that form is called set dependent relative. That is, if you are dependent on your child throughout and you are now due for indefinite. So maybe our sister Boatin will be able to use that form. And the person who came earlier on, again, you have to add more information to show whether you go for set LR or you use set dependent relative.
0739920848, or leave your comments in the comment section down below, either on Facebook, YouTube, or you can call 0208 493 7345. Let's pick another one. Naneti Ahene, please, a woman has British child from different relationship, or he has British children from different relationship. Now, in relationship with another man and have another child who is British, or 2.5 years, depending on the woman's status. The man is facing removal, but all four members live together about less than 2 years. The relationship is 1 year subsisting. Will the man's application be considered under partner route, exceptional circumstances, or direct access, or even pure human rights? Lawyer.
Well, I mean, technically, caseworker will say you don't qualify because you are not married to. So let's look at the other child now in a relationship with another man and has another child who is British, 2.5, depending on the woman's state. Oh, okay. So the woman is British, right? And the child, no. So help
No,
me with the second line.
the woman has a British child from a
No,
different
no, no. So
relationship.
now the second one. So now so this woman is in a relationship with another man, which is the
Another
man
who
who
is
is being
British child.
the man who is being deported, right?
Yeah.
Yeah, with another man, and they have another child who is British. That's what I'm looking for. But here he says that who is British or 2.5. How can a British child also have 2.5?
Obviously, that was a question I was going to ask. Yeah.
Yeah, so that doesn't um, make it easy for me to. That's why I said no. I want to interpret that line properly. It says I have to know what the fact said. So is it the child who is British and so the woman has 2.5? Or this child, the other child that the man has with the woman has 2.5, which is which? But again, let's put it all together. I'm sure Etuahine will call later to clarify. But in this case, if the woman, if the man has a child who is British, as we have in the first part of that sentence, then the child is a qualifying child. If the child is a qualifying child, then the father of the child will say that I want to rely on my qualifying child to remain in the UK under direct access provisions if the man lives somewhere else and the child lives with the mother and other siblings elsewhere. That is one. On the other hand, if the child has 2.5, but the mother is British and the siblings are also British, and the child who has 2.5 lives with them, in other words, the mother and the siblings. This man whose child has 2.5 is saying, I want to remain in the UK to depend on my child who has 2.5 visa. Well, that would be a bit because this child who has 2.5 is not a qualifying child, and so cannot qualify to based on whom you can remain in the UK on the basis of Appendix FM. However, if this man has married this woman, then the woman has children already who potentially are British children, as you said. Then the British child, who is the stepchild of this man, because the man is married to the woman, can apply on the basis of the stepchild. Because the man is less than 2 years in a relationship with the man. So there is no relation, the criterion for relationship is not established. Unmarried partner must be in a relationship for 2 years, but they are in a relation for less than 2 years. So on that basis, marriage can help him to become a step parent to the British child. But if his own child is British, then it's obvious that he is the parent of a qualifying child. The sound.
AA Music Entertainment presents Emmanuel Praise on the 25th of May at the Pavilion, 143 to 146 Oxford Road, Reading, RG1 7UY, featuring Irabna, Joyce Blessing, and hosted by Alex Achampo. Doors open at 5, with a concession price of £15 for children from 5 to 16 years old. Tickets are £35 standard, £60 double, £60 VIP. Includes a VIP seat, meet and greet the artiste, take pictures with the artiste, VIP snacks, water and drink. Get your tickets at alexichampon.com or call 0744 741 73. With Irapna and Joyce Blessing and hosted by Alex Achampo. It's guaranteed to be awesome.
Yes, we're back, and we will go on to the phone and take one last call. Then, when we come back, we go to look at our quiz. And I have 3 statements, and I want to find out which of them you think it's true based on the scenario I'll give you. Hello.
Hello.
Okay.
Hello.
Yes, October again. Yes.
There was a question from one Piano or something. I would like to know if, let's say, somebody is married they were not married, they were partners. And then through the British child, the man had 2.5 years, 2.5 to live here on the basis of the stepchild. And then after some time, there was a bit of problem. So the man has moved from the house where he's married. So the man has moved from the house. Now the man is this for another 2.5 years. But because there's been a bit of separation, he's not living with the children. He has 2 children with the woman. What's going to happen with the man's application? What kind of application is he going to do? Because now they are not living together and they are not married in the UK. But the first 2.5 will be given on the basis of the stepchild. So what's going to happen?
Okay. Asma.
Uncle
Yeah.
Charles Asma, my secretary.
Well, you've turned him into
My lawyer, my secretary.
your lawyer. Thank you. I think that's the right one. Okay, Uncle Charles.
Yeah. So let him pause a bit. Is he gone?
No, he's here.
Oh,
Good.
I'm
So
on,
help
yeah.
me. Help me. So the first one I have was based on the stepchild, right?
Yeah, the first one was based on the first stepchild.
Good. Good. Stay there for me. And after this, he had children or a child with the woman. So he now has a biological child, right?
Yeah, that's the biological child.
He now has a biological child. Is this biological
Yeah,
child
with the woman.
British?
Two biological children. Yeah.
Are they British?
Are they?
No, they are on their 2.5 as well.
So these children are not British.
No, they are not. His children are not British.
So what it means is that if the man is leaving the UK and he says that I want my children, after all, the children are not British children, so they can follow him. That is the law.
Okay.
But because the children themselves are not independent, they have because the mother has, or maybe, no. So how did the children have 2.5? Is it based on their sibling?
Yeah, based on the mom getting 2.5 as well from the British
Yeah.
child.
So based on the sibling who is British.
That's right.
Good. So you see, the man cannot rely. So now the analogy. These children are begging to survive, aren't they?
Yeah.
So they don't even have it. Can they give to their father?
That's the question because they have the
No, no,
2.5
no,
as
no.
well.
But I mean, that is the logic of this question. You don't have it. So how can you give what you don't have? If they are all living together, then the argument will be that he has a stepchild who is a qualifying child. He also has other children who are not qualifying children, but they have lived to remain in the UK. Having lived to remain in the UK, you cannot pass it to your father because you are getting it from somewhere. Are you with me?
Okay. Yeah.
So you can't give what you don't have. And the only time you get to give is when you are a qualifying child. But your question will be, can there be a discretion from the caseworker? If the caseworker wants to exercise discretion, that's fine. But when this man is making the application, he cannot be emphatic on the law to say that the law says, give it to me because I have a child who is a qualifying child. He can't say that.
Yes. So, what will be his option then?
Well, he can try. It's not within the law, he won't get it. But, well, I don't know what he wants to do. Okay, he can go back home. He can go back home. He can go back home, reconcile with the lady, and say, you know what, I'm back home. Forgive me. I want to be a better person. I want to look after the children. Trust me. Blah blah blah. Then life starts again. Then when he's due to apply, he continues to apply on the basis of on the basis of where he started from.
Yes. But that's my one complexity of the case. The child of the man, the first child of the man, the biological child, is now 10 years. Okay. The man's visa is expiring next month.
Oh, yeah.
And
Now, hold on. No, hold on for me. Hold on. Henry. You have not introduced a new fact. So the new fact is that,
can the child apply as a British citizen? And then later on, but the dad is going to be overstay anyway.
okay, hold on for me. That's what I'm saying. You have introduced a new fact, which will be helpful to your client to this case. Now, the child who is now 10 years or nearly 10 years was the child born in the UK.
Yes, he was.
Oh, then the child is a qualifying child because the child has been in the UK for 7 years and born in the UK.
Yes.
So the man can apply with based on direct access with a qualifying child.
Okay, so he's gonna start the 2.5 again. The other two and a
Well,
half is gonna be there.
he can apply to extend 2.5. This time based on a qualifying charge different from the one before.
Okay, all right.
But he must show direct
Thank you
access
very
with the
much.
child. So he has to prove direct access. Okay.
Yeah, okay. Then. I'm on the motorway, so it's a bit strange. So I will speak to you
Uh,
later.
yes, and make sure you are safe and you're compliant with the law.
Really, I'm
So
using a earpiece, brother. Oh, well, I'm coming to you. I'm coming to London now to
let's
celebrate my birthday with you. So I'll see
please,
you later.
please get in touch. We are here and ready for you. Thank you very much, Atubab. And with that, I think we go off the phone lines because we almost running out of time. Now let's look at the scenario I gave you. The quiz scenario I gave you was about Mary, who's a trader in Ghana and was applying to join her British husband Kofi John, a cleaner in the UK. Eno has postponed her application for the last 2 years because she cannot afford the $6,500 fee. Which of the following statements is true? One, Eno can apply for a loan to make her application. Two, as her husband is a cleaner, Eno can ask for a discount. Is three also true? If Eno and Kofi can show the evidence that they cannot afford it, it will be waived. What are your answers? Drop them and let's pick that one up. Hegel Paul says is one, Eno can apply for a loan to make an application. Thank you, Hegel. The next one is from Emmanuel Labi. He says number three, if Eno and Kofi can show that they cannot afford it, it will be waived. Ima, thank you. Next one here we have Harriet Balfour. Hetty says, Harriet, sorry. As her husband is a cleaner, Eno can ask for a discount. The next one is from Albert Bedeako. Number three, Eno and Kofi, if they can show evidence, then it will be waived for them. Next is Oseko for and Oseko for things that Eno can apply for a loan to make her application. Ivan Satobra thinks it's number one. Yes, thank you, Evans. And that will get me to go to Lawyer Asma to find out which of the three is true. Could it be one, two, or three, or all three of them? Lawyer.
Okay, so let's take them in turns and we'll conclude. Eno can apply for a loan to make her application. There's no law which says that if you can't afford, go for loan. So that is out.
Okay.
Two, as her husband is a cleaner, Eno can ask for a discount. There's no law which says that depending on the job your husband does, he can come for a discount. So no. Three, Eno and Kofi can show evidence to be able to get a fee waiver. And if they can, they get a fee waiver. There's a law which says that if you cannot afford, you can ask for a fee waiver if the application is human right application. And because this is a human right application to join a spouse, then if they can't afford, they qualify to ask for a fee waiver because if the caseworker says no, then it will go against Section 6 of Human Rights Act and also the provisions of the immigration rules and the fee waiver provisions.
So, as Law has stated, it is number three. If Eno and Kofi can show with evidence that they cannot afford it, it will be allowed. The waiver would happen. So, yes, that's that. Thank you very much. And know that affordability fee waiver overseas human rights based application is Article 8 and it's published. It was published on the 16th of June 2022. With that, I'll go back to Lawyer Asma and we're going to look at what topic we discussed this afternoon, how to challenge a deportation from the UK for being an overstayer and on human rights. Lawyer.
Thank you very much once again for staying with us. Today's conversation was on an overstayer's right on the basis of human rights to fight deportation from the UK. As an overstayer, if you prove that you have human right with your partner or with your children or child in the UK, you can rely on that Article 8 right to plead against your removal from the UK. In this case, you have to show that you meet the requirement for that particular Article 8 right. If it's partner or spouse, you have to show that you meet Appendix FM or family life provisions for partners. If it's a child, you have to show that you meet Appendix FM provision for parents. In this case, if the conditions are met, you are likely to succeed, especially where there is a child involved. However, if there's no child involved and it's just your partner, then because you are both adults, the law is that you have to show that your absence from the UK will bring hardship to you or hardship to that family member. If the family member is going to be in hardship due to your absence, then it will be an exceptional circumstance to be considered, even though the rules may not be met because you are an overstayer. So if you're an overstayer and exceptional circumstances such as hardship or insurmountable obstacles apply, then you are likely to succeed. In this case, you put in an application called human right claim in writing, sent to the caseworker or sent to the border force that is dealing with your removal case. They would make a decision on that. If the decision is allowed, then you have got it. If it's not allowed, but you have an appeal, you'll be asked to go home and you'll be asked to leave detention or stay on and appeal your case. If it is without appeal right, then it will be certified. In this case, they will still attempt to remove you from the UK. In this case, you have to go to the upper tribunal to seek judicial review of the decision not to give you right to appeal against their decision to refuse your human rights claim. If court or upper tribunal, which is the judicial review front, if they consider your application and they give you permission to seek judicial review, then you can fight your case up to the end. There are instances where the Home Office will withdraw or will ask you to withdraw your claim for them to reconsider the decision. If they ask you to withdraw your claim to reconsider the decision, then you are likely to be granted or refused. But if refused, you'll be given an appeal right to then go to the lower court, which is the first tier tribunal immigration, to appeal the matter, which can take 48 weeks before it ends. Now, if it's the case that the court is not going to grant or they are going to refuse your claim, your application for judicial review, then Home Office will insist that the judicial review application did not succeed, and so you are going to be sent away from the UK. If court accepts the application and Home Office does not ask you to withdraw, then the case can continue from upper tribunal to court of appeal to even up to Supreme Court. And that's going to be a long stretch. And in this case, you can never be removed from the UK insofar as your case is still pending determination. This is what we have concluded on, that if you're an overstayer, you can rely on your human right, if you have one, to fight a deportation against you, and you are likely to operate within the rules and assert your rights. Thank you.
Thank you very much, Lasma, for your kind gesture, for your time, and of course, the share of knowledge. And to those of you who were able to call in, those who sent you your questions, and all the other people that were able to come in to us, we do really appreciate your time and your effort. It's been the community and the law brought to you by BWF Solicitors. To the lawyers, the caseworkers, and all the family members of BWF Solicitors, we want to say thank you so very much for giving us another opportunity for the research and the share of knowledge. We appreciate that so much. And to you out there, I want to say thank you very much. Without you, we didn't have a program. So we want to do it again. Are you ready? Yes, we'll come back same time next week on the same platform to do it again. We'll be bringing another very lively discussion when it comes to the law. And to Sheila Ankra and Padmo Dodu for doing the admin and the aesthetics, and to my studio producer, Professor Ade, for helping put it together and giving it to you as well. My name is Ulrich Frimpong. Have a good evening.